think EU sanctions law and compliance is fascinating, but also very tough because, correct me if you disagree, but the legal bases in the treaty for adopting sanctions are extremely broad. The regulations are not very detailed in the definitions. For a lot of things, there is simply no guidance at all. And for the significant guidance that's been issued by the European Commission under the Russia-Belarus 2022 onwards sanctions, there is a lot of detail. So how do you think the court, can come in and providing a bit more stable guidance? And do you view the reference for preliminary ruling as a viable avenue to expect that guidance, or do you think it should be coming from somewhere else? And if so, from where?
Mhm. A very complex question. Of course, in the ideal scenario, the guidance would come from the decision makers, that is to say, the council, perhaps a bit more the commission, with the court only playing a supplementary role. The thing is that we see that in practice, a lot of the questions arrive on the court's docket and the court has to deal with them. I think there is definitely a role for the court to play, though you can see that it's not always adamant to provide definitions when it doesn't have to. I think what the court is trying to look out for, and we see that increasingly in recent cases, is to maintain the consistency and the uniformity of EU sanctions law. And we see the court now looking more and more about, let's say, the internal consistency of regulation, looking at whether provisions contradict each other and how to build a coherent rationale. So we see the court looking at this. It doesn't mean necessarily that it provides definitions, but at least I think it's a welcome development. Now, I think that the court sometimes, indirect action does not have the incentive to make the interpretative effort that preliminary questions might make it to do. For example, there was a direct case of Friedman, I think, who was complaining about an EU sanctions, I think the reporting obligation for listed targets. And he argued that, well, the notions of ownership and control are so difficult and so contradictory depending on which member states interprets them, that really there's divergent interpretations everywhere and that this doesn't work. The court replied in the direct action that no, actually those notions are fairly clear and that they don't raise enough uncertainty as to really create a problem of legal certainty. Judging at all the questions raised by national judges, clearly the court either misunderstands the nature of the divergent interpretations or did not want to engage with those. But with the questions arriving to the court now, it might be forced to actually answer those questions.